Thank you for joining Mayor Brown's webinar. Our program today will focus on ethics and internal investigations. I will cover a few administrative matters and then get started. First, at the bottom of your screen, you will notice there are multiple application widgets you can use. All the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. Today's program is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presenters. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or browser sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off your VPN is recommended. If your slides are behind, pushing F5 on your keyboard will refresh the page. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. During today's presentation, you will be provided with an alphanumeric code. If you are applying for CLE credit, you will need to record this code on the virtual sign-in sheet that you received by email with the connection details. You can also find a copy of the virtual sign-in sheet in the resource list widget entitled CLE Affirmation Form. Directions for returning the CLE Affirmation Form are on that sheet. I will read the code in the middle of the presentation and then again at the end. Please note, we also made the event evaluation form and presentation deck available in the resource list widget for your convenience. This webinar is being recorded, as we normally do with these programs. In a day or so, we will be sending you an email with a link which you can use to listen to the webinar again or share with your colleagues. The recording will also be posted on our website. I plan to allow time at the end of the program for questions. To submit a question electronically, please use the Q&A widget. If I don't get to your question during this webinar, I will make every attempt to follow up with you afterwards. My name is Lori Zahalka, and I'm delighted to participate in today's topic. I serve as one of Mayor Brown's risk management and loss prevention attorneys. In this role, I advise on professional responsibility and ethics matters that arise in Mayor Brown's offices. I'm also a member of the firm's Ethics and Loss Prevention Committee. With that brief introduction, let's get started with today's program. So today we're going to be talking about internal investigations and the ethics rules that apply to them, and we'll do so through the hypothetical that's up on your screen. It's an email to the General Counsel of Alpha Corporation from the Controller regarding the CFO promotion process. And the Controller writes, I write to make a formal complaint about Alpha's failure to promote me to the CFO position. After 2 decades of loyal service to the company, I am eminently qualified for the position. It's no coincidence that each time a senior leadership position becomes available, the board conducts a search for younger external candidates rather than looking to more mature, loyal candidates from within the company. I also believe that I am still suffering the fallout from my decision to notify the board that Alpha's Springfield branch has been overcharging its biggest customer, Beta Corporation, in collusion with a certain corrupt buyer at Beta, in order to reach revenue targets and bolster earnings guidance provided to the public. My lawyer has advised me that I have strong legal claims against Alpha related to its decision to pass over me for promotion to CFO. I demand that Alpha look into this matter and remedy its wrongdoing in an appropriate manner. So we have here an employee who's making a complaint of what seems to be age discrimination and also possibly retaliation. So the in-house legal team decides to launch an internal investigation into the CFO promotion process and also into the allegation about one of the branch offices overcharging Beta Corporation. And the first question they think about is whether Alpha is now under a duty to preserve documents and other information as a result of receiving this email from the controller. And the standard used to answer that question is whether it's reasonably foreseeable that a lawsuit will be filed. And that comes from the Zublake case in the Southern District of New York from 2003. And I think receiving an email like the one from the controller where the person is represented by an attorney and is claiming discrimination and retaliation is probably sufficient to put the company on notice that there is a reasonably foreseeable chance that a lawsuit is going to be filed. And so the answer to whether or not there's a duty to preserve documents, it would likely be yes in this situation. So not only is there applicable case law that sets out the standard, this issue is also governed by the rules of professional responsibility. I set out here Model Rule 3.4a provides that a lawyer cannot unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. And then the comment to that particular section of the rule emphasizes that the right to obtain evidence through discovery is important, and it can be frustrated if relevant material is altered, concealed, or destroyed. And so to put it in context of thinking about whether to preserve evidence once a company receives an email like this, there might not be an affirmative step to destroy or conceal evidence, but the fact if a corporation isn't going to put a legal hold in place to preserve evidence, it could possibly be destroyed by users deleting it in the normal course of business, or data could be destroyed pursuant to the company's regular document retention policy. And so, and that could potentially be a violation of Model Rule 3.4. Moving on to the next slide. So assuming that preservation is warranted, well, what should the company do? First, think about key witnesses. So in the context of the CFO promotion process, you want to think about anybody who had a hand in making the decision, possibly other candidates within the company who were interviewed. You'd also want to identify relevant IT staff who can help the legal department identify and collect relevant emails, figure out where relevant documents are stored, and how to go about preserving them. Once the key witnesses and staff members have been identified, then the next step would be to issue a litigation hold to all relevant individuals involved, asking them to at least preserve evidence relevant to the CFO promotion process, and depending on the circumstances, either forward that information to a particular person within the legal department or segregate it within their own email accounts. And an interesting question that I sometimes get from clients is, well, when does the obligation to preserve evidence end? And in the context of litigation, that answer is a little more easily answered. It's when the litigation is over and there isn't a chance for appeal, you're probably safe to lift the litigation hold. But in a situation where litigation never materializes, you've got to use the same standard as you used when you were thinking about whether you were under a duty to preserve evidence, which is litigation reasonably foreseeable? And it's really a judgment call. You might use a statute of limitations. If the statute of limitations on any cause of action has run, then it's probably safe to release the litigation hold. But again, there's always an element of risk there in thinking about when to release a litigation hold and allow information and data to be destroyed pursuant to a regular retention policy. We're moving on to the next slide. So once the company has determined that it's under a duty to preserve evidence, the next step that it would like to take is to review emails of relevant witnesses, including the controller, that were sent or received on their alpha.com email addresses and or through their office computers. So what considerations are relevant here. First of all, is this kind of general email review permissible? I think the first thing to do when thinking about conducting an email review is to take a look at the company's computer usage policy. Sometimes it's called an acceptable use policy. Most policies these days inform employees that they should have no expectation of privacy in anything that they do on the employer's computer equipment or on the employer's network or internet connection or their system, no matter how the employee accessed the system. A well-drafted policy should also inform employees that all activity on the employer's network and hardware may be monitored. And just to flag an issue with respect to monitoring, I wanted to mention that in certain jurisdictions like Connecticut and Delaware, there are statutes requiring notice to employees in advance of monitoring computer usage and work emails. And then there are other jurisdictions like California, Colorado, Indiana, Oklahoma, South Carolina, and Utah that require employers to obtain consent before monitoring. So be aware if your particular jurisdiction has a statute that governs monitoring of workplace electronic communications, and make sure that you have the necessary notices and consent before implementing a policy of monitoring. So hopefully your company has that kind of a policy and sets forth those warnings to employees that they have no expectation of privacy and that their activity on the employer's network is going to be monitored. We'll talk in a little while about what happens if your company doesn't have that kind of a policy, but hopefully it does. And generally, a general email review of data and information on a work-issued computer or the employer's network is going to be permissible. And the seminal case in this area is City of Ontario versus Quan. The citation is set out here on the slide. Although this was a case that arose in the context of government employers, so there were Fourth Amendment issues, really this case sort of set out the principle that even if an employee has a reasonable expectation of privacy in communications conducted on employers' networks, employers can have a legitimate interest in reviewing those communications and other materials if there's a legitimate work-related purpose for doing so. In Quan, the employer had issued police officers pagers so that they could communicate with each other during work hours, and the the officers were informed that any texts that they sent on the pagers were subject to the police department's electronic communication policy, which told them that they had no expectation of privacy with respect to those communications, and that there was the possibility that the employer would be monitoring or auditing their use of the texting function. The policy also prohibited conducting personal business during work hours. Well, officers were continually going over the texting limit of whatever plan the employer had signed up for, and so the employer decided to do an audit to see whether it was necessary to increase the data plan that they had. As a result of this audit, they realized that Quan was sending copious amounts of text of a personal nature while he was on duty, and he was disciplined for that. And he claimed that the review of his texts was a violation of the Fourth Amendment. The court said, well, yeah, he had a reasonable expectation of privacy. Even if he had a reasonable expectation of privacy, they assumed that he did. The employer's review was still permissible because it was necessary for a work-related purpose. And the city had a legitimate interest in determining whether the text limit was inadequate. Moving on to the next slide. what should Alpha do if during the review, during its email review, it discovers that the controller exchanged emails with his lawyer on the controller's Gmail account, but while he was using his computer, his work computer that was issued by Alpha? So we'll go into a little bit now about different cases exemplifying the boundaries of employer computer usage policies and just how far particular terms will allow employers to go in finding and using materials of a personal nature. As I'm sure won't be surprising to many of you, how this issue resolves itself is going to largely depend upon the jurisdiction that you're in, but we'll go through some cases that sort of highlight different ends of the spectrum, and we'll also talk about the ethical rules applicable to the discovery of material that could be protected by the attorney-client privilege. So moving on to the next slide, we'll start with the Holmes case out of California. Here, the employer had a pretty robust policy that provided that the employer could inspect all files or messages at any time for any reason. It advised employees that they had no right of privacy with respect to the use of company technology and that email should only be used for company business. It also prohibited employees from sending or receiving personal emails. And the court in this case, the employer in this case uncovered attorney-client emails that the plaintiff had sent to her lawyer from her company-issued computer and company email address. And the court held that the email communications between the plaintiff and her attorney were not protected from discovery by the attorney-client privilege, relying on the policy that the employer had in place. The employee was on fair notice that the employer was going to be able to see those, and they therefore were not confidential and were not protected by the attorney-client privilege, and therefore could be used in the litigation. Moving on to the next slide, we'll switch coasts and go to New York to look at the Pure Power Bootcamp case. Here, as in Holmes, which is the case from California that I just discussed, the employer had a robust policy that prohibited internet access for personal use, informed employees they had no expectation of privacy, reserved the employer's right to review, monitor, and access any matters stored in, created on, received from, or sent through the employer's system. Here, the employer, the employee had saved his Hotmail email account password on his work computer so that when you went to the Hotmail website, it automatically populated with his password and you could just get into the account. So the employer, after the employee left the company to start his own business that was in competition with his former employer, realized that it could get into his Hotmail account, did so, went through all the emails, and in doing that, found an email that reflected the former employee's Gmail account password. So then the employer went to the former employee's Gmail account and looked through all of those emails, and through its review of the Hotmail and Gmail account, learned that the former employee had yet a third email account, and the employer went to that email account and guessed at the password because it was the same and it happened to be the same as the Gmail account and the Hotmail account password, and went through that third email account and reviewed all of those documents. And one of the emails that the employer found was communication that the former employee had with his attorney about the terms of his non-compete agreement with the employer. So, not surprisingly, the employee complained about this and brought a claim for violation of the Stored Communications Act, which is a federal statute that prevents unauthorized access to email communications. And the court said that the employer violated the statute, the access to the email accounts was impermissible, despite the fact that the employer had this robust policy in place. And the reason that the policy didn't save the employer was because none of the email accounts that the employer had accessed was stored on the employer's computer. The only thing that was on the employer's computer was the password, and so the court analogized to, it's like if the former employee had left the key to his house sitting in his work desk when he left, and the employer took that and went to the employee's house and rifled through every single thing in his house. It's not, leaving the password on the computer was not a license to go and troll through all of his personal emails. So that's sort of the other end of the spectrum in terms of permissibility of email review. Going to the next slide, and this is the final case we'll talk about with respect to email review, is the Stangard case in New Jersey. Here, the computer usage policy of the employer wasn't quite as robust as it was in the previous two cases. Although the policy provided that employees could be monitored and with or without notice, it permitted occasional personal use of the employer's systems. And like the employee in Pure Power, Stangard used her work computer to communicate with her attorney, but she was using a personal email account. And somehow those emails that she sent from her personal email, she was on her work computer doing it, those became cached in the computer's memory. And when the employer went to review all of her email communications and did a forensic review of her computer, they found these emails stored there. Here the court held that the emails were protected by the attorney-client privilege and therefore had to be returned to the employee and couldn't be used in the litigation. The court said that the plaintiff had a reasonable expectation of privacy because the policy was ambiguous. It said nothing about the employer reviewing personal email accounts and didn't warn the employees that contents of email sent from a personal email account could be stored on an employer issued computer hard drive. And also, the court relied on the fact that the policy provided for occasional personal use of email. Also of note, the court said these emails are attorney-client privileged. Also found that the defendant's attorneys, because they did not inform the plaintiff about the discovery of the attorney-client emails, violated the applicable rules of professional conduct. And we'll get into what those rules are in just a minute. But also, it's notable that the court said even a clearer policy would not have removed the attorney-client privilege nature of the emails because of the important public policy concerns underlying the attorney-client privilege. So I think that just serves to underscore that, you know, courts thinking on these issues about whether or not the attorney-client privilege has been waived on emails that are sitting in on an employer's computer or their network are going to be protected really can vary by jurisdiction. Moving on to the next slide, this is the particular rule of professional responsibility that applies to inadvertent sending of attorney-client communication. So it provides that a lawyer who receives a document or electronically stored information relating to the representation of the lawyer's client and knows or reasonably should know that the document or electronically stored information was inadvertently sent shall promptly notify the sender. And this is the rule that was at issue in the Stangard case. And you know, even though you might not think of that situation as sort of an inadvertent production issue, the court still found that this rule was applicable and the attorneys had violated it because they didn't notify the employee that they had these emails. Now, comment 2 to Rule 4.4 clarifies that whether the lawyer is required to take additional steps beyond notifying the adversary, such as like returning the original document, is a matter of law beyond the scope of the rules, as is the question of whether the privileged status of a document has been waived. So the rule of professional responsibility doesn't talk to whether an attorney is obligated to return the document or whether there's been a waiver of the attorney-client privilege. All it calls for is for attorneys to give a heads up to either the former employee, or if he or she is represented by the attorney, I would say notifying the attorney that that you're in possession of these documents that are arguably covered by the attorney-client privilege. I think we can skip over the next slide. That goes over the comments that I just discussed. So I guess the key takeaways from the section that of the presentation that we just went over about email review is review the company's computer usage policy to see exactly what it says and how much protection it might provide you in reviewing employees' emails and work computers. And what if the company doesn't have one? Get one drafted. It's an important thing to have. If you're in a situation where you've got to conduct a review and you don't have a policy, I think you should still be okay to conduct the review so long as it's narrowly tailored to the circumstances of the situation. And I think that would be true even if you have a policy. You don't want to have a wide-ranging review of anything that you might turn up. You need to have a legitimate business purpose, and your search needs to be narrowly tailored to that. Nonetheless, if you don't have a policy, there is an argument that there's been nothing said about occasional personal use of employer systems for electronic communication that increases the risk that an employee might have a colorable claim for an invasion of privacy, at least with respect to communications of a personal nature. So just be aware of that risk when you're conducting the review. And then keep in mind, as I mentioned before, there's some states that require notice and or consent for monitoring of electronic communications. It's not okay to directly access an employee's personal email account, even if the password has been automatically saved to the employee's computer. That's not licensed to go in there and review everything that's in that personal email account. It's a different story, of course, if some of those personal emails are somehow saved in the memory of the computer or somehow saved on the employer, otherwise saved on the employer's network. And if the search and review reveals potentially privileged material that the company intends to use in connection with the investigation or any eventual litigation, attorneys are obligated in most jurisdictions to inform their adversary that they are in possession of that privileged material or potentially privileged material. Keeping in mind, of course, that the rules of professional responsibility themselves take no position on whether the discovering attorney is obligated to return or destroy the material. That's really an issue for the courts to decide. Turning back to our hypothetical, as on the next slide, as part of its investigation, Alpha now wants to review the Facebook pages and other social media activities of relevant witnesses, including the controller. So is this permissible? Are there any limitations on a social media review? And the short answer is it may be permissible for them to review some social media activity, but there are definitely limitations. And I've set the two primary ones out in the next slide. The first one is the Stored Communications Act, and I mentioned that previously in the presentation. The citation is here. But this is an older statute that was in place even before the advent of social media, but it provides punishments for whoever intentionally accesses without authorization a facility through which an electronic communication service is provided. There are cases that have held that the Stored Communications Act is applicable to social media sites, and so this effectively prevents employers from accessing social media accounts without authorization. And we'll explore what that means in the context of social media and internal investigations in just a second. The other big limitation, depending on the state in which the employee is located, are laws that prevent employers from requiring applicants and employees to disclose social media passwords. So in the context of Alpha's investigation, it can't go to the controller or any other relevant witness and say, provide me with your Facebook password or your Instagram password so that I can go in there. I need to look and see if there's relevant information. Not all states have those laws, but many, many do, so it's worthwhile to check in your jurisdiction if you're going to undertake a social media review as part of an internal investigation. So now let's look at some cases to see how the Stored Communications Act has been applied to employer social media review. The first one that I've got here is Elling from the District of New Jersey in 2013. This is the case that concludes that the Stored Communication Act applies to Facebook wall posts when a user has limited his or her privacy settings. So if the account is private, an employer cannot access the private postings without authorization. The SCA prevents that. This case also explores the authorized user exception to the Stored Communications Act. And here we have, the facts are that a coworker presented the employer with social media postings from another employee, and this coworker had access to her coworker's social media account. They were friends on Facebook. And she saw these posts and thought that they were concerning from an employment perspective, so she printed them and showed them to management. And management went on to discipline the employee who posted these things on Facebook, and she brought a lawsuit under the Stored Communications Act claiming that the employer was not authorized to have those posts. And the court held that no, it was okay for the employer to take action as a result of having these posts because the original employee who brought them to management's attention was an intended viewer of the post because he was Facebook friends with the plaintiff, and there was no coercion. The employer didn't say, hey, I understand that you're friends with this person on Facebook. Can you go onto their wall and print off some posts for me? I think this case underscores that employers will lose protection of the authorized user exception to the Stored Communications Act if they coerce access to Facebook accounts or use other underhanded tactics to try to get access to social media posts. Okay, moving on to the next slide is the Petrillo case. Here the employees had set up an invite-only website on myspace.com that criticized their employer. The employer asked one of the employees for her username and password to the website, and she provided it. Based on what the employer saw, it terminated some of the employees who had participated in the discussion on MySpace. The employees sued under the Stored Communications Act, and they also brought common law claims for invasion of privacy and wrongful termination. The jury determined that the employer was not properly authorized to access the website under the SCA because its request to the employee for her username and password was coercive. And that determination was based solely on the employee's own testimony that she felt that there may have been negative consequences if she did not give her employer her password. So this is sort of at the opposite end of the spectrum from Elling, where somebody brought something totally unsolicited to the employer's attention that was on social media. That was okay. Here you have the employer asking if an employee will allow access to a social media website using password, or if you're friends with somebody else on Facebook, you have the employer affirmatively asking, can you help me out here? That's going to be impermissible, even if, there may be an argument that, well, she could have said no. I still think, given the dynamic of the employer-employee relationship, there probably is likely to be an element of coercion there, and it's probably not a good idea to ask employees if they will help provide evidence from other people's social media accounts that they're friends with and as part of an internal investigation. On the next slide, I have a couple of just additional considerations for companies that are going to undertake a social media review as part of an internal investigation. Social media accounts can contain a lot of personal information about people, including information about protected categories of information that might not be obvious from interacting with the person in the workplace, related to sexual orientation, religion, political activities, things of that sort. And so it's always a good idea to try to have someone other than the folks who are going to be making a decision about the internal investigation, or who have decision-making power over a complaining employee's employment, to review social media accounts, so that only information that's relevant to the investigation filters through to the decision makers. So there's no appearance that somebody's protected characteristic was, you found out about this from looking at my Facebook page, and that's really the reason that you're taking these adverse actions against me. And then there are also National Labor Relations Board issues related to social media posts. You've got to consider whether any work-related social media post might be considered concerted activity under the National Labor Relations Act. And if it is concerted activity, employees can be protected from adverse employment decisions based on that activity, unless certain exceptions apply. So I just wanted to raise those two red flags. I'm not going to get into more details, although I'm happy to answer questions after the webinar about these two things. But those are two red flags to be aware of when you're conducting a social media review. So in general, what's in somebody's social media public profile or publicly available just by going to the person's profile on the internet is fair game. Don't ask employees for their passwords if you're in a jurisdiction that has a law prohibiting such a request. And don't try to obtain access to employees' social media accounts through surreptitious means, like asking a coworker to friend the complaining employee or follow the complaining employee, or asking a coworker who's already an existing friend or follower of the person at issue to download information from the profile and provide it to you. Okay, moving on to our next section, going back to our hypothetical. As part of investigating the allegations concerning Beta, Alpha's investigation team considers calling the Beta personnel alleged to be colluding with Alpha, introducing themselves as a competitor of Acme, and asking about pricing issues. The investigation team also wants to create fake social media profiles and attempt to friend or follow the controller on social media. Is this permissible? No. And we'll talk about why in just a second. What if instead the team wanted to retain a third-party investigator to make those calls to Beta, presenting themselves as a competitor of Acme and asking about pricing issues? What if the investigation team asks a coworker to friend the complainant and get access to her private posts that way? All of these things are likely to be impermissible under the professional rules of responsibility, because they all involve misrepresentation by the attorney himself or herself, or somebody acting at the direction of the attorney. And so we'll go through some of the model rules that apply in this context and prohibit that behavior, or that conduct. On the next slide, we've got Model Rule 4.1a, which provides that in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. So that would squarely apply to calling Beta Corporation and pretending that you're somebody else and try to get information from them. Similarly, it would squarely apply to creating a false social media profile in an attempt to gain access to private social media posts. Model Rules 4.2 and 4.3 which apply to communications with represented, which is 4.2, and unrepresented persons, which is 4.3, are also applicable here. If a person is represented by another lawyer, a lawyer shall not communicate with that person about the subject of the representation. And if a person is not represented, a lawyer shall not state or imply that the lawyer is disinterested. Move on to the next slide, which outlines a couple more applicable rules. First here is Model Rule 5.3, and this applies to the situation where Alpha considers hiring a third party to call Beta and present themselves as an interested buyer. A lawyer shall be responsible for conduct of non-lawyers employed or retained by or associated with a lawyer that would be a violation of the rules of professional conduct if engaged in by a lawyer, if the lawyer orders or with the knowledge of the specific conduct ratifies the conduct involved. So if the lawyer can't do it, the lawyer can't direct another non-lawyer to do it and can't sort of passively allow a non-lawyer to engage in conduct that would violate the rules, because that would be ratifying the behavior. And finally, we have Model Rule 8.4, which is sort of a catch-all. It's professional misconduct for a lawyer to knowingly assist or induce another to violate the rules of professional conduct, or to do so through the acts of another, which sort of echoes 5.3. And the second part of 8.4 is it's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And I've also provided a cite here to a Philadelphia ethics opinion from 2009 that's on point with respect to social media review. A lawyer may not use third person to contact or friend non-party witnesses to access her private Facebook or MySpace pages, even if there are no affirmative misrepresentations made. Just to wrap up, a couple of summary points on this pretexting issue. It's not okay to create fake social media profiles. It's probably not okay for the lawyer himself or herself, particularly if you know that the employee or the witness is represented by counsel, to try to friend or follow the person on social media, even if you're not misrepresenting who you are, because you're not disinterested, and if the person is represented by counsel, it might be construed as an attempt to communicate with the represented person. And I'll just emphasize just one point that I forgot to mention before. If a coworker were to come to you as the employer with sort of unsolicited with information from somebody else's social media account that you determine is actionable from an employment perspective, you likely wouldn't run afoul of the law as it currently exists or the rules of professional responsibility in taking action on that information. But it's probably not advisable to ask the coworker to go back and get additional information from this person's social media page. They haven't, in essence, opened the door to have you basically use them to mine a social media account for relevant information. Okay, moving on to the last section. Going back to our hypothetical, after reviewing the relevant emails and documents and social media accounts, the investigation team is ready to interview witnesses employed at Alpha. What preliminary comments should the interviewing attorney make at the beginning of the interviews concerning the attorney-client privilege? And probably most everybody is familiar with the Upjohn case. You've got to give Upjohn warnings to witnesses, and so what should that warning comprise of? And I've got the points set out here that the interviewing attorney represents the company only and not the witness personally. The lawyer is collecting facts for the purpose of providing legal advice to the company. Legal advice to the company. The communication is protected by the attorney-client privilege, which belongs exclusively to the company and not the witness. And the company may choose to waive the privilege and disclose the communication to a third party, including the government. Once these basic points have been addressed and the witness has been given the opportunity to ask questions, it's advisable to memorialize that the Upjohn warning was given in some way, and it's usually by counsel noting that it was provided in a contemporaneous memorandum summarizing the interview. Of course, the facts of any particular situation or investigation may justify a departure from these general principles, but these are the general outlines of the Upjohn warning. On the next slide, there's a couple of model rules that are applicable in this situation too that lawyers should be aware of. Model Rule 1.13F provides that in dealing with an organization's directors, officers, employees, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. And that's covered by the first point in the Upjohn warning in the previous slide, which is that you're informing the person that you're interviewing that the lawyer represents the company only and not the witness. And Model Rule 4.3, in dealing on behalf of a client with a person who is not represented by counsel, the lawyer shall not give legal advice other than the advice to secure counsel. If the lawyer knows or reasonably should know that the interests of such a person are or have a reasonable possibility of being in conflict with the interests of the client. I think this could come up quite frequently in witness interviews. I think it's a natural inclination of employees to say, well, am I in trouble here, or what's my exposure? And attorneys conducting the interview have to be careful to say, I can't provide you with legal advice. If you want answers to those questions, I advise you to consult an attorney. Moving on to the next slide, can the interviewing attorney instruct each witness that the witness is obligated as a condition of continued employment to keep the interview's contents strictly confidential? I think this is appealing for employers to tell employees. There's a lot of common sense reasons why employers would want to keep an internal investigation and the sorts of questions that you're asking confidential. But there are a few minefields here from the government that they don't like this. That may change under the current administration, but we'll talk about the state of play as it exists right now, and it's an area to keep an eye on. First, we'll talk about the SEC. In April of 2015, the SEC announced its first enforcement action against KBR for using overly restrictive language in confidentiality agreements. The SEC alleged that there was a violation of the Dodd-Frank Act because KBR presented interviewees in internal investigations with a confidentiality agreement, and the language is set out here in the slide, but it basically says, I'm not going to discuss anything that we discussed about in this interview or any subject matter discussed in the interview without prior authorization of the law department. And I understand if I do that, I could be disciplined up to and including termination. The SEC didn't like that because it conveyed the message that witnesses could not go to the government to basically not whistleblow in appropriate circumstances. And so KBR ended up settling with the SEC, and as part of that settlement, it agreed to amend its confidentiality agreements to state explicitly that employees are free to report potential violations to the SEC or other federal agencies without notice to KBR and without KBR approval. So the revised language is that they could keep the language in the confidentiality agreement that's set out in the slide and had to add on that nothing in this confidentiality statement prohibits me from reporting possible violations of federal law or regulation to any government agency or entity, including but not limited to the Department of Justice, the SEC, Congress, any agency inspector general, or making other disclosures that are protected under the whistleblower provisions of federal law or regulation. I do not need the prior authorization of the law department to make any such reports or disclosures, and I'm not required to notify the company that I have made such reports or disclosures. So from the SEC's perspective, a blanket confidentiality requirement or telling interviewees at the outset of the interview that they absolutely have to keep this confidential is going to pose a problem. And then on the next slide, we also have NLRB issues. There are several board decisions indicating that employers cannot broadly prohibit employees from discussing company investigations without providing a justification. So I've set out two citations here that discuss the issue. In both cases, the companies regularly instructed employees involved in investigations not to talk with other employees about the subject matter of the interview. And in Banner Health System, an employee was actually disciplined for failing to abide by that confidentiality warning. And the NLRB said blanket confidentiality restrictions are not okay under the National Labor Relations Act because they send the message to employees that they cannot engage in concerted activity regarding wages and other working conditions, and that sort of activity is protected under the NLRA, and you're telling them that they can't engage in that. They can't discuss with their employees things that are going on in the workplace. The NLRB, these decisions go on to say there are some situations in which a blanket confidentiality requirement would be okay, and those are instances where there's a witness that's in need of protection, there's evidence that's in danger of being destroyed, there's testimony in danger of being fabricated, or there's a need to prevent a cover-up. So those are relatively limited circumstances. I think the bottom line here from the NLRB's perspective is that there needs to be a case-by-case determination based on the facts as to whether a broad confidentiality restriction is needed in any particular internal investigation with respect to any particular employee. The other thing that I will note is that in Banner Health Systems, the employer tried to argue that protecting the integrity of its investigation was a good enough justification for its broad confidentiality requirement, and the board said no. Similarly, in another case, the board said even if you've got some sort of savings clause in a confidentiality agreement that says you've got to keep the contents of our interview confidential, but nothing in this agreement is designed to prevent you from exercising your rights under the National Labor Relations Act, that was similarly not okay. It's got to go back to the four circumstances that I outlined: a witness in need of protection, evidence in danger of being destroyed, testimony in danger of being fabricated, or the need to prevent a cover-up. I will say that there has been some indication that the NLRB will be revisiting this. There was a new general counsel that came in, and in the changing of the guard there, they set out some priorities for changing certain board rulings, and this Banner Health System ruling was one of them. So this is an area that's changing, and it's important to monitor any developments. And with that, I think we have one more. What should the investigation team do if the controller demands to have his own counsel present at the interview? I think if that were to happen, I think under the professional rules of responsibility, the investigative team would be required to abide by that request. Model Rule 4.2 says in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or court order. And comment 3 just underscores that the rule applies even if the represented person initiates or consents to the communication. In that circumstance, the lawyer must immediately terminate the communication with the person if after commencing the communication, the lawyer learns the person is represented. So even if the controller were to say, yeah, you know what, no big deal, we'll go forward without my attorney, it's probably advisable to reach out to the person's attorney to the extent that you can, to just make sure that as a professional courtesy, you're letting them know that the controller is or the employee at issue is wanting to move forward without them being present. Okay, so with that, we've finished the presentation. We just have a few minutes left. I don't know if there were any questions. It doesn't, oh, sorry, let me take a look at this. Okay, so we have one question. Can you check a public social media profile that is public for purposes of an investigation or ongoing issue? Yes. If it's public, it's fair game. I would just caution, and what I said previously in the presentation, which is that it's advisable to perhaps have someone who doesn't have decision-making authority to go through that public profile to call out any irrelevant information, particularly irrelevant information that could reveal a characteristic about the person that's protected by law. I've got another question. I mentioned that California requires consent before electronic monitoring. What about Idaho and Oregon? The answer, I don't know the answer to that question. I'm happy to look into it and get back to this particular person after the webinar. Another question is, are these rules applicable for internal investigations not conducted by attorneys and not under an attorney's direction? Some of them are, and some of them aren't. I think if the model rules of professional conduct aren't applicable to non-attorneys who are not acting at the direction of an attorney. Other things like the rules about confidentiality from the SEC and the NLRB are going to be applicable regardless of whether or not it's an attorney conducting the investigation. Similarly, I would say the things that I discussed about the social media pretexting and sort of using surreptitious means to access Facebook accounts and other means of electronic communications, I would say are applicable. The Stored Communication Act is not limited to governing lawyer conduct. I think we have time for one more question, so I'll ask, in view of the state of the law around direction on keeping interview confidential, what is the recommendation on how best to address? That's a good question. You know, it's a tough question, and I think it's going to depend on the factual circumstances of what you're investigating and who you're talking to. I think in KBR, certainly, so from the SEC's perspective, I think it would be okay to say we expect this to be kept confidential, perhaps to memorialize in writing that although we expect this to be kept confidential, it's okay to discuss this with your attorney if you're represented by one, or a government agency. The NLRB, it presents a stickier issue because even telling an employee that they can go to the government isn't going to address the NLRB's concerns about allowing employees to talk with one another. and to engage in concerted activity. So I would say unless you can have a good faith argument that a blanket confidentiality requirement falls into one of the 4 categories that I outlined, it's probably best not to tell employees that they're prohibited from discussing it with their employees or their coworkers. With that, if there's any other questions, I will do my best to address those offline as soon as possible. That wraps up today's program. On behalf of Mayor Brown, thank you for your time. I hope you found the program useful. Some final housekeeping items for today's participants. A recording and link to the materials from this program will be distributed by email to you in the next day or 2. Thank you for participating. This concludes our webinar.